The first case is State of Ohio, City of Akron versus Raymond Owen. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your arguments. You can refer to them by initials or terms like the child, if that applies. We have read your briefs and are ready to proceed when you are.
Good morning, Honors. Catherine Megan on behalf of Mr. Owen. I would ask to reserve 5 minutes for rebuttal. As a housekeeping matter, I just informed the appellee this morning that we will be withdrawing our 4th assignment of error in this case. So we'll be arguing the first 3. So I represent Mr. Owen, and essentially we're here challenging his conviction for sexual imposition following a jury trial that occurred in the Akron Municipal Court. 3 assignments of error before the court today would be whether or not there was sufficient evidence to support that conviction, whether or not the conviction was supported by the weight of the evidence, and then whether or not the direct examination testimony of the victim in this case should have been essentially considered by the jury as it was unsworn. Regarding sufficiency, I think what the case comes down to really here is purpose. I think there was no question, and I know the court probably has the exhibit and saw the video, that there was sexual contact that occurred here. And even Mr. Owen himself, when he testified during his case in chief, did not dispute the fact that that contact did occur. But I think what it comes down to is, was there sufficient evidence to establish that the purpose of the touch in this case was for sexually arousing or gratifying either person? The testimony that we heard from the victim in this case was that she had been vacuuming around the bar. Mr. Owen had also been standing at the bar speaking to some individuals, put his arm out, may have had some incidental contact with her at that time. Some sort of verbal exchange occurred. She went in to give him a hug. He reciprocated that hug, and as he hugged her back, that's where the contact occurs. You can see on the video there is some communication between the two of them. He throws his hands back like this, looking as if he's apologizing. And so, again, I think when we look at everything in context, was there sufficient evidence to show that the purpose was to sexually gratify either himself or the victim in this case? I think the evidence was lacking in that regard from a sufficiency standpoint, but more importantly, when you look at it from a manifest weight standpoint, we do have conflicting testimony, which in cases where one person has one impression and another person has another impression, that makes sense. So we have the victim in the case indicating that the contact, obviously, she felt it was on purpose. His testimony was that it wasn't. And I think the important things when it comes down to considerations here, the case that I cited, I think it was the Antoline case, where obviously the victim can't testify what the defendant's purpose was in his conduct. The jury certainly can infer things through circumstances, but one of the other things that they can consider is the personality of the defendant, and that's the things that came out during his case in chief in terms of his standing in the community. Even through her direct examination testimony, she had indicated this person has been at the bar several times. They've never had a negative interaction. Every interaction they had was positive. There was never any sort of incidents like this in the past. And I think that kind of bolsters his position that this was an incidental thing. And again, I know there is video. You can see him reach his arm sideways, and it's kind of an awkward position that they're in. And so absolutely no denial that the contact occurred here. It's just, was there the purpose for that sexual gratification or arousal of either party? And I think that's what's lacking. The 3rd assignment of error, where we raise the issue on the testimony not being sworn. I know that the state indicates it was something that was brought up by the prosecutor. However, before direct examination ever occurred, or I'm sorry, cross-examination occurred, the defense attorney said, hey, I need a moment. I presume that he went over to the state and said, hey, this witness wasn't sworn, and then that turned into a sidebar where it was realized that the witness wasn't sworn. And so I think that's a flaw that occurred here. I don't think we have to prove plain error because I do think that it was brought up by the defense counsel. So it wasn't as if they were sitting on it to try to use that to their advantage later.
Well, wouldn't the objection had to be done at the time the examination started? I mean, if someone's first question is hearsay, you can't wait till they're done and say, hey, we want to say this is hearsay court. You got to object at the time to start when the person was sworn in, you know? The court can correct it at that point?
So I think if it, yes and no, I understand your point because it would make more sense to bring it to the attention when it occurs. It may have been something that both sides didn't even realize until they were into it. And so I think when you realize, hey, I think, take a step back, we're missing this step, it's important to bring it up. That type of error, I think, is important to raise whenever you recognize the fact that it occurred. As opposed to maybe it was just, again, an oversight by the court. And so drawing attention to it at any point, had it been happened at the end of the trial, I think it would have been a bigger problem.
Did you, at the time it was brought up, and I don't recall on the record, did defense counsel then object to what the court was going to do, which is we're now just going to swear her in at this point, and we're going to say everything you said true? Did the court say, no, you can't do that, you got to do something else?
Correct. So there wasn't any objection by the defense. However, the actual swearing in isn't in the record, so we can tell that it happened. So when you look at the transcripts, the judge says, I guess I forgot to swear you, I'll do that now. And then it just says, there's like an excerpt that says she was sworn under oath. There wasn't anything in the transcript where the court said, now everything you said previously, did you tell the truth? That's not in the transcript. I guess we can infer that that's what occurred, but that itself isn't there. And so I think that's what's problematic as well.
Is that how, and look at the transcript, is that how the other witnesses in the transcript show up as being sworn? In other words, the verbatim swearing in is not included, it's just this person was sworn in?
Sure, and I believe that's correct. I don't think the actual language of the oath is within the transcripts. So here it's kind of problematic because it's hard to say whether or not the court said, hey, you know, you were under oath, was everything that you said true to the best of your knowledge? Like, we don't know that that occurred based on just the face of the transcripts itself. I would presume that's what happened, but I can't say.
Well, the record's silent as to that.
Right,
I'll
correct.
take your comment on that.
If there are no further questions, I'll just reserve the balance of my time.
And I want to make sure I heard you correctly. You're
Sure.
withdrawing the assignment of error.
Yes, assignment of error 4 were
Fair
withdrawn.
enough. Thank you.
There was a stipulation that was filed previously. Thank you.
If your honors are ready. Good morning, and may it please the court. I'm Jacqueline Corgan on behalf of the city of Akron, the appellee in this matter. And the city is asking this court to affirm because none of the 3 assignments of error that have been argued here have any merit. I'd like to get to the last point that Judge Stevenson, you were making with counsel, and I'd like to leave with that regarding the oath that was delivered to the victim in this case after she gave her direct testimony. I would like to point out to the court that take a look at page 80 of the transcript where where the sidebar occurred. It was requested by the prosecution and it was drawn to the court's attention that the victim had testified on direct, not under oath. The court does ask the victim, after placing her under oath, whether the testimony that she had just given on direct was true. The victim then says yes, and then cross-examination of her proceeds. So I did want to draw the court's attention to that. And regarding, Judge Stevenson, your question as to when an objection should have been more appropriately raised, the case law on this assignment of error dictates that trial counsel are supposed to raise this error as soon as they possibly can. It's supposed to be done in a timely manner, because when you really have error is when the witness is allowed to leave the stand, and only then does someone say to the court, you know, the oath was never administered to this witness. So the preferable way to do this is at the beginning of testimony or as soon as possible. possible. And in this case, it was done after the close of direct testimony by the prosecutor. The court takes the sidebar, then informs the jury and the rest of the court. The oath has not been administered. It is in the record that it was administered, and then, as I said, the court asked the witness to affirm whether she had testified truly and accurately, and she did.
And then does the record establish that once the judge attempted to cure in this fashion, the defendant did not further object and say, no, I object, you can't cure in that particular fashion?
There was no objection of that nature raised at all by the defense after that. Instead, defense counsel proceeded to cross-examine the victim, who then, on cross-examination, ended up repeating the same information that she had already given on direct as a course of her cross-examination. For instance, she testified after receiving the oath, everything that established the elements of the offense with which Mr. Owen was charged. That he grasped and squeezed her breast, that he told her he would go easy on her breasts, that she shoved him away, that she admonished him that this was not a consensual touch, and so that established the elements of the offense after the oath was delivered and on cross-examination. In addition, just to focus a little bit on the oath for just another second or two, because the prosecution raised it, it would have to be noticed by this court on plain error, which is pretty rare, because Mr. Owen would have to show not only an error, which is the jury's reliance on the unsworn testimony of the victim, but also that without that unsworn testimony, he would not have been convicted. That's the prejudice prong. And he can't demonstrate either, because the record indicates that when the jury was asked by the court after the verdict was delivered what they relied upon in reaching that verdict, they essentially said the video. One or two of them said that affirmatively, and when the court said, is that what the rest of you relied on, there's an indication in the record that they all indicated affirmatively, probably by nodding. So that's what the jury relied upon, was the video, not the testimony of the victim on direct. And in addition, with that video, there's no possibility that Mr. Owen could show that without that direct testimony that was unsworn, he would not have been convicted. So there's no possibility of prejudice there. Now, regarding sufficiency and manifest weight, the city contends that it met its burden of production, not necessarily proof, but production regarding the sufficiency analysis, but in addition, that the mere fact that the jury believed the prosecution's version of events over Mr. Owen's version of events and over his testimony concerning his character does not mean that the jury lost its way and created a manifest miscarriage of justice that this court, that all three judges of this court would have to agree would merit a new trial. And as counsel mentioned, the key to this case is Mr. Owen's contention concerning his purpose in grasping the victim's breast. His contention throughout has been that this was an accident, and the city's position has been and continues to be that regarding a sufficiency analysis, the jury had before it the victim's testimony and the video at issue, and from that was entitled to infer Mr. Owen's purpose and to determine, based upon the type, the nature, and the circumstances of the sexual contact in this case, what his purpose was, and that's supported by this court's prior precedents. As far as, because he's only indirectly challenging the recklessness or the knowledge component through the claim of an accident, both recklessness and his knowledge of the offensiveness of that touch can also be inferred from the testimony of the victim, her reaction to the touch and the videotape itself. And that, for instance, is in City of Akron versus Hawley, regarding knowledge, where the defendant said, I have no reason to know that this contact would be offensive, and her reaction, though, was sufficient to indicate that he knew that this would have been offensive. So the jury was able to infer that without any direct testimony from a defendant, that satisfies sufficiency. Regarding manifest weight, the character evidence that a defendant is allowed to bring in concerning their own character is not dispositive. Again, manifest weight always gets down to the jury being entitled to choose which side of the case they will believe. And generally, it is only when this court would look at the evidence and determine that the evidence in the case is inconsistent with the verdict. And all these judges in this panel must agree on that when it's a jury verdict. So it has to be a unanimous decision that the verdict does not square with the evidence. And it has to be something that this court cannot overlook, because this court doesn't overturn a case on manifest weight grounds lightly, nor does it do so merely because the jury believed the prosecution's version of events over that of the defendant. So unless this court has further questions, then the City of Akron would respectfully thank you and ask you to affirm. Thank you very much.
You'll have your full 5 minutes on rebuttal.
Thank you. I'll just be brief. I do have a couple of different comments. Just going back to the unsworn testimony aspect. We don't have the actual sidebar conversation on the record, so we don't know who said what. But what we do know, what we can see from the record was prior to cross-examination, the defense counsel said, can we have a moment, or can I have a moment? Presumably there was some sort of conversation with the state, or then the state said, can we approach? And then a sidebar occurred. We were talking about when to raise an issue. I believe had the state realized that the victim wasn't under oath, that probably would have been something that they brought forward before they continued on with their examination. I do think that, again, just looking at what we have in the record, and it's hard to tell, I think it was probably something that was noticed by the defense counsel, brought it up to the state, and then it turned into a sidebar with the court, and that's how we got to, hey, guess what, the victim wasn't sworn. I know that this state's pointing you to page 80 of the transcript. I reread it yesterday. I did not bring it with me today. I do not believe there is an actual statement where the court asked the witness if their prior testimony was true and accurate. I do think there is a question posed of whether or not their testimony from that point forward will be true and accurate, but I don't think that it's in the record the other way. As it relates to, again, sufficiency and manifest weight, I think the big thing here is going to come down to purpose. I know that it's probably more significant from the manifest weight perspective, and I get it. This court can sit as the 13th juror to determine whether or not the jury lost its way. And that's why I think that Antoline case, which is 2003 Ohio 1130, is important, because when you're looking at the lack of direct testimony coming down to what the purpose is, the trier of fact can infer from the nature and types of circumstances, but also the personality of the defendant. And so that's the thing that I'm asking this court to consider. When you're listening to the type of person that my client was, and you watch the video about what occurred and you see his reaction after the fact, I think all of those things could point to the fact that the jury lost its way in their interpretation of what happened here. To watch something on video, absolutely one thing. You see what you see.
Going back to the oath issue, there's an
Sure.
argument that most of the things that were testified not under oath in direct were actually testified to in cross-examination. Is that true? Is there something missing from cross-examination?
I would have to go back and reread the transcripts off the top of my head. I assume there are absolutely things that were repeated during the cross-examination that occurred on direct examination, but off the top of my head and without the transcripts in front of me, I did not piece those things together.
Would there be an issue of prejudice then if everything that wasn't sworn came out in cross-examination?
The things, I don't think there would be prejudice if there were things that came out in cross-examination that were previously brought forward on direct. I think it would only go to the things that didn't come out on cross-examination that were testified to previously.
Thank you.
If there are no further questions, we would just ask the court to reverse this case and send it back to the municipal court for new trial. Thank you.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision as soon as it's issued. The opinions are also posted on the Ohio Supreme Court website. Thank you both for your presentations.